All right, last time, before me, 2 Thanksgiving meals, which were really good. You had 3? I'll leave it alone. Before that, we read Article 4. And let's just talk down through some of that, mostly to get our mind back into class. This is to put you to sleep before we get to new material so that you have no hope of getting the new material down. So that is not the case. Let me just ask some questions to help us at least get our eyes back to the Constitution and find the right place in our notes, find the right file to open up. So, all right, the very first paragraph, I'm on Article 6, let's go back to Article 4, talks about full faith and credit. What is the basic thought of that statement? Full faith and credit shall be given in each state to public acts, records, and judicial proceedings of every other state. There are some real questions that come out of it, but what's the basic thought?
Birth certificates all apply, debts all apply. I can't incur a debt here and run to Illinois.
Okay. Any type of official legal document here is recognized someplace else. If you declare dead here, except for Chicago, then being dead doesn't matter. You can still vote and participate fully in the government. But states have to recognize those types of things. And we said there are some real questions that come up, especially now with gay marriage. And there was a Defense of Marriage Act that said states did not have to honor that. Now we have the Supreme Court saying it's a constitutional right to gay marriage, which is insane. All right, what is the next paragraph getting at? The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Is this something like we're doing tomorrow afternoon with the flu shots? Immunities? People from Illinois can come here and get flu shots?
Yep.
Free of charge?
States can't discriminate against other citizens from other states. They have to have the same laws for both.
Yeah. If there's a 10% sales tax, then it applies to both citizens and non-citizens for people that start a business, or just whatever the rules and restrictions are. It can't be that if you get stopped speeding in Indiana, but you live in Illinois, the fine triples or something like that. The same, those rules all the same. All right, what's the big fancy word that goes with the next paragraph? The person charged in any state, etc. Extradition, yeah. And what entity has to start that process to get the criminal brought back? What's that? Could be a kid, you're right.
The executive branch.
Okay, the executive branch, basically the governor and his offices would have to start that. How is that different with the next paragraph that talks about slaves fleeing? Who has to initiate there? Oh.
The slave owner.
The slave owner, the person who owns the property. All right, let's see here. The very last paragraph, it says, the United States shall guarantee to every state a republican form of government. We said there were 3 basic things that includes, at least in the mind of the founding fathers. That meant 3 basic things. What were those 3 things? Just one. Popular rule, the people voting, choosing their leaders, that type of thing. No monarchy, so the people can't vote to pick a king, no matter whatever the people choose, it can't be a monarchy. And then rule of law. So we want to tackle that one and tell us what it is. Megan doesn't. You don't actually have to tackle it. Just describe it and be fine. Did you already go to sleep? You should be well rested, alert. Jim? Or who are you pointing at? Oh, Bethany wants to answer? Oh, Josh is pointing like you were all excited about this.
It's where it's not a man making his own laws. The established laws, what
Okay, there's some written law, some written rule that describes what happens. Okay, that is something I mentioned last time. We are losing in our country the idea of the rule of law. Even the refugee situation, Obama's just wanting to ignore the written law and just make these special exceptions to let them in. All right, that's not the rule of law. That's the rule of man. So, all right. Turn the page too quick. We got 5, 6, and 7 to do next, and I'd like to at least get that much done. They're all nice and short, relatively straightforward, especially 7. If you flip there, I mean, it's really straightforward. All right, number 5, Article 5 deals with amending the Constitution. Amending the Constitution. What process has to happen for us to change this document? It's happened. Can we think of a famous example of where the Constitution was amended? Don't worry, if you think of any example, then we'll assume that it's famous. Should we, make everybody answer once? No? Come on, somebody. Don't worry, if you get it wrong, we will laugh at you. Some of them we talk about pleading the Fifth, right to remain silent. That was added as an amendment. People talk about the Second Amendment, the right to bear arms, keep and bear arms. Okay. How about freedom of the press, freedom of religion? Right? All those were added as amendments. Okay, so this process has been done, all right, and some very good things have been added and tweaked into the Constitution. So our founders knew that this thing was not perfect, and especially as the situation changed, this document might have to adapt to meet those situations. Yes.
Was the prohibition, wasn't that an amendment?
Yeah, to prohibition and then getting rid of prohibition, both amendments. Yeah, so it's been done. We've left trying to amend the Constitution in the last 40 years and have gone to just let the courts do something like they did with gay marriage. Just say, oh, it's a constitutional right, or abortion. Just reinterpret all the language to mean something it doesn't and create these new rights, that's a dangerous way to go. Imagine, I don't know, if you had to take the loan for not having your school bill paid. Is that still the program? Okay. If you had to take the loan and you sign saying this kind of money, and the bank comes to you a year later and says, well, we know you signed saying you'd pay 8%, but if you look in the fine print or you look in the Greek, or it really means 18%. That's what the 8% means. It really means 18%. You're going to say, wait a second, no, there's some words right there. It says, all right, and we've allowed as a nation us to get used to that idea that these words don't mean what they say. Okay, and that's a very dangerous place to go, and that's the way we've headed. A good example of really where it's not the rule of law anymore; it's the rule of man, whatever the Supreme Court says. So, all right, let's look at how this thing is supposed to be changed. It is intentionally meant to be a slow process to make it very deliberative, so that it would not be changed very rapidly. There's been a couple that have been done very rapidly, and those have been some very stupid ones for the most part. All right, let's just read through the start of it and see if we can pick this thing apart. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to the Constitution, or on the application of the legislatures of 2/3 of the several states shall call a convention for proposing amendments. Okay. Now, right there, whether or not we pulled it apart properly, there are 2 different ways that amendments can be proposed. Right? I could stand here in class and say, I think we should have this amendment added to the Constitution, but that doesn't mean anything. For it to officially be proposed, there's only 2 ways. Kind of analogous to when we saw a bill, a law, the lawmaking process. Someone in Congress has to actually propose the thing. Right? This is how we get those 2 things proposed. And there's 2 options. The one is through Congress. Congress can propose amendments, and it's 2/3 of Congress required to make this proposition. Congress can say we'd like to make an amendment requiring the federal budget to be balanced every year. They wouldn't know what to do with that. Actually, they would just print more money and say, "Oh, look, it's balanced now." But anyway, they can propose that. But some member of Congress can get up and say this is an amendment we like. It would require 2/3 of both houses to start that process. Right? If you think back to the lawmaking process, all that needs to happen is somebody get up and say, "Hey, this is the law I'd like to have." Fill out the paperwork. It might not go anywhere, but at least it's been started. Here, for the thing to get started, it requires 2/3 of both houses. Okay, even at this point, a high bar to get to, much more than just passing a law. Okay, the other option is called a national convention. And here what happens is 2/3 of the state legislatures could call for a convention. All right, so it's not, the state legislatures aren't making the proposals for amendments. The legislatures are calling for a convention that the states would send delegates to. And then that national convention could make the proposals. Anybody follow Mark Levin? Oh, have you heard him talk about this?
Not recently.
Okay.
I'm allowed to listen to the college.
Oh, yeah, sorry. So, it's been a while ago. It's a good cover. I wasn't trying to entrap you. Anyway, he talks, I don't listen to him a lot, but I do hear him talking about, he is proposing and pushing for this national convention because Congress is not going to propose an amendment that requires them to balance the budget or something like that. They're not going to do that, right? But it could come this way. It completely circumvents Congress, okay? So, all right, so we have 2/3 of Congress proposing it, or 2/3 of the states calling for this national convention, and then at that convention they could talk about different amendments that they'd like, and that amendment or that convention can then propose different things. That meeting is called the National Convention. That's never happened, all right? But it is a constitutional option, and one you can see on both sides of this. There's a way to circumvent Congress. It gives the states, if they choose to exercise the power and authority, a way to change the Constitution without Congress really having any way to make any real stumbling blocks in the process. So there's a little bit where they can meddle with it, but they could completely circumvent it. Okay, so those are the two ways it can be proposed. That's it. There's no other way. So some people are fearful of the National Convention. The thought is that once this thing gets called together, it could really go pretty much any direction that they want to. You might have been with a group of kids, like Ann last Friday night, where about 3 a.m. they decide to start playing a new game, and it goes some direction she wasn't initially thinking. Okay, and that's kind of the fear here with the National Convention, that it might start going someplace kind of crazy and not the initial purpose for it. I don't know. It's never happened. We don't know. At this point, I think I'd take it. If 2/3 of the state called for it, it'd be hard to do worse. Really, if you think about Congress and what they did, it'd be hard to do worse. So, okay, those are two ways it can be proposed. Once it gets done with that step, it is not an amendment yet. It still has to be ratified, officially accepted. The next part here gives us two options for that. Okay, let's go on here. Let's just read through the whole thing, and then we'll get to the new part. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified. And here we have the ratification process. When ratified by the legislatures of 3/4 of the several states. Okay, so there we have 3/4 of the states having to agree with this, which is a very high bar, right? The 3/4 of the state legislatures agreeing to this new idea that's being added to the Constitution. Or the second option, or by conventions in 3/4 thereof. Okay, so once once it gets proposed, however it happens, it goes back to the states for this ratification process. And it can either be the state legislature, the currently existing state legislature voting, or it could be that the state calls for a special meeting of delegates to look at this amendment and vote on it. Okay, so those are the two options. Okay. And if you want to be not technical, but it says 3/4 of the states have to approve it. It does not say that 3/4 of the state legislature has to be in favor. It just has to be a majority in the state legislature, but 3/4 of the states have to agree to it. Okay? So those are the two options for amendment. We have two ways it can be proposed, two ways they can be ratified, sorry. Let's go on. As the one or other mode of ratification may be proposed by the Congress. Okay, so it does here give Congress the authority to pick if it's going to go to the state conventions or state legislatures. It doesn't give them really, they would try the option of not, they would have to take a long time and they would do studies and it would be a 3-year process for them to decide which way they're going to go with it. But if they're willing to drag it, but that's the only thing. Congress does get to pick state legislatures or state conventions. It's not up to each state to decide individually or even up to the national convention if it comes that way. Congress gets to pick that. Good? We got to do something for Dustin. He's really looking like he's in pain. Sleepy and in pain. That's a very, very unhealthy place to be. All right, we have some qualifications added here. Provided that no amendment shall be made, which may be made prior to the year 1808, shall in any manner affect the first and fourth clauses in the 9th section of the first article. Everybody remember that? Let's look. All right, so we're going back to the first article, 9th section, first and fourth clauses. All right. What's the first clause deal with? Yeah, the importation of slaves. That cannot be changed. And I don't have it written down here. The fourth one would be then the direct taxes and all of that. Okay, so those two things were explicitly off limits prior to 1808. And then the last one, and that no state without its consent shall be deprived of its equal suffrage in the Senate. So that part cannot be changed unless some state willingly agreed to it. We could have 3/4 of the states voting to make Senate representation based on population, right? But the other quarter of the states would not be forced. They would have to agree to that before it happened. So, basically, that equal suffrage can't be touched, and the slave issue before 1808, the importation. Okay, so other than just a few little things there, the whole document is up for grabs. Not to mean that it's getting changed willy-nilly all the time, but the whole document is up for grabs. Okay, what are the two ways that an amendment can be proposed? Somebody who hasn't answered yet. Since you just talked about these, you can look in your notes. And if you didn't write anything down, then you can look in your friend's notes.
It requires 2/3 of both houses.
Okay.
And the National Convention, 2/3 of the state legislatures, they call for a convention.
Okay.
State Senate representatives.
Yeah, that's it. 2/3 of Congress or the National Convention. Those are the two ways it can be proposed. Well, the two ways it can be ratified. Should I have you stand up if you've yet to answer, just so we can easily identify you? I should have them stand up here and face the camera, so everyone else can identify them as well. You did? Cheater. Is that 10 demerits? That's good. Dustin.
Ratified by 3/4 of the states
Okay. In which there's two options.
to be ratified.
Yeah. It's 3/4 in either case. It's the state
Legislature.
or the state.
Convention.
Yeah. All right. Congress could say, all right, we want every state to have a special meeting, and you elect people special just for this issue, or they could say, just let the state legislatures do it. Either one. Josh?
Oh, I'm wondering if I got this wrong. It's 2/3 of the House that can call a convention, or 3/4 of state legislatures? I thought it was 2/3.
Oh, maybe it's 2/3 in both cases. Sorry, did someone do it wrong? Who mentioned?
3/4, so.
It says 3/4.
No, for ratification it's 3/4. For the proposal it's 2/3. Ratification is 3/4. Yeah. Whew. And to pass the law is only a half, and how much to override a filibuster? That'd be a fun matching section. Put all these fractions on one side and have you match them to.
Especially if somebody's saying with like 3/4 thing.
Yeah. And then throw some extra fractions in there. Just not to trick you, just to make sure you understand. It was not to trick you at all. So, yeah, 9/16. 17, 30 seconds. That would be even more fun. You guys should be teachers someday. Well, you guys are education majors, aren't you?
Yeah.
See here, teachers do have evil minds. That's just, you'll be evil mind? Oh. Okay, one last thing to comment about the amendment process is that this was intentionally a cumbersome thing. All right? It was meant to be difficult to do. I mentioned that at the beginning, but just to make sure, it wasn't something that our founders wanted to be done very, very quickly. And this particular copy doesn't have them. I've got them here someplace, I think. Let me just give you some examples. 14th Amendment, which has issues and problems, which we'll get to. It was proposed by Congress in 1866 and wasn't ratified until 2 years later, 68. If you get up to some of the amendment that changed representation in the Senate, the election of senators, that was May the 13th of 1912, and was ratified April the 8th of 1913, so less than a year for that one. So there's been a couple that came through very, very quickly, and it kind of illustrates the point that we really need to stop and think about this some. It was intentionally a slow process. So, all right, if you want some numbers, these are a little bit old. Over 5,000 have come up for discussion in Congress. 33 have actually been proposed, and then 27 have actually been ratified of the Constitution. And only one of them went through the state conventions. Right? All the rest have gone through the state legislatures. So. Okay, amending the Constitution. Amazingly short little section. So they must not have been writing essays for a government class where try to cover up your ignorance by the blizzard of words. Somehow hide it in there, hoping you cover it up. So. Okay, that's Article 5. Article 6. Article 6. Come on, go back there. Yeah, we call this one just general provisions. This is all the stuff that didn't fit anywhere else, so they threw it here. This is the, probably your kitchen at home has a junk drawer, okay? Or maybe a junk cabinet, or maybe the kitchen is a junk room. Everything that doesn't go anywhere else, you just throw in the kitchen. I don't know. Probably have a section like that. We have a junk drawer, and then above that there's a cabinet that tends to be kind of miscellaneous, junky things that get thrown in there. So anyway, this is that section. Not this is junk, but just stuff that really didn't fit other places. So we just have these general ideas put here. All right, the first one. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. Okay, what is that thing saying?
Any debts that occurred before the Constitution was ratified are still valid?
Yeah, they were going to still pay the debts. Okay? And hopefully you're thinking, well, of course, it's the same country. Right? But historically, of course, this isn't the way to look at it. Historically, many times, some nation will form a new government and write a new constitution, and they just walk away from the debts. They say, oh, wow, you better go talk to those people. They're not there anymore. That's a lot of money. Hope you can find them and collect them. They walk away from it, all right? We were saying no, and this is really the only right thing to do. It's the same country. It'd be like when Pastor Damon came in as pastor saying, oh, we're not going to pay off those debts. That was, go talk to the other guy. No, it's the church that contracted the debt. All right? And that's what they're saying here. So it really is, it should be a common sense thing here, but they're stating it just to make sure. This was as much for other countries as it was for us. Right? There were countries we owed money to, and we didn't want them to begin to get worried about getting paid back. That sometimes isn't real good for relations when they think you're not going to pay them back. So this makes it clear. We're paying it all back. All right. The next paragraph is special enough that it's called the Supremacy Clause. And it basically states that the Constitution is supreme, but we'll read it. The very first part of it is technically the Supremacy Clause. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. Okay, so if there's something in the Constitution or a law from Congress or a treaty that goes through the right processes and is ratified, those things, if you've played Rook, trump things that the states do. All right, they take precedence. If I don't know, if Illinois, while we're picking on Illinois, they voted to get rid of this messy, cumbersome legislature and pick a king. The Constitution says, no, that can't happen. The Constitution takes precedence. They've been very close to that in the past, especially Chicago. They've had some basically king figures. All right, so if the states want to do something that goes against the Constitution, laws of Congress, or the treaties that come along, those things take precedence. So it is supreme. All right, this is different from the Articles of Confederation. Right, there's nothing there that stated this type of thing, and there really was. It was much more. The states were supreme, and they would allow the national government to do things when they thought so. Here, this is saying the things that are given to the national government, they have exclusive jurisdiction over. They are supreme. Okay, which is appropriate. All right, let's go on. The second half of that one. And judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. Okay, so judges in the Indiana courts are forced or supposed to abide by the Constitution. If there's a conflict between the state constitution or some state law and the U.S. Constitution, that judge is supposed to side with the U.S. Constitution. So it's forcing this onto the legal system, even into the state and local levels as well. Okay. Pretty straightforward, I think. Next paragraph. The senators and representatives before mentioned, and the members of the several state, we get a whole list of people here. All the senators and representatives in Congress, the members of the several state legislatures, so the members of the Indiana state legislature, all executive and judicial officers. Should I start waving the marriage slips at them? That might get their attention. All right, I lost my spot. Members of Congress, members of the state legislatures, all executive and judicial officers, both of the United States and of the several states. Okay, so this is a wide swath. All the judges in the states, the governors of the states, all the officers in the governor's departments, all the state legislatures, as all those same people for the national government. All those people tells us what has to do here. Shall be bound by oath or affirmation to support this Constitution. Okay. So they all have to take an oath. It does not give the wording here like it does for the president, but all of them have to swear to support the Constitution. It is the supreme document across the whole country in the areas where it speaks, and it's appropriate for all of these levels to acknowledge that as they're taking their position. So, anybody remember why there's the option for oath or affirmation? Is it for people who have long names? They could take the oath and there's still space there for their name, since affirmation is much longer. We have a couple that haven't answered yet. Nothing? Robert's frantically writing. Not sure what he's writing, but Shem? Always listen to your friends. It's a safe thing to do. I heard it. For religious reasons. For people that feel it was somehow immoral to take an oath, they could affirm. To me, it's like saying, I'm not going to drink beer, but if you put it in a pop bottle, then I'll call it pop and drink it. Not that taking an oath is the same thing as drinking beer, but anyway, to me, it's a little bit of getting a little bit nitpicky with some semantics. But for people that had some religious conviction against an oath, they could take an affirmation. So, all right. Last thing here in this paragraph, in this article. See how fast this makes up for the 4 months we spent in Article 1. All right, but no religious test, excuse me, no religious test shall ever be required as a qualification to any office or public trust under the United States. All right. Can anybody notice the wording here and what is being restricted here to not having a religious test? It is the national government. Okay, so it's saying, that we can't have Congress pass a law saying if you want to be president, you have to be Presbyterian or something like that. There can never be that type of religious test for the national layer. Yeah.
But technically, if that just applies to government, for immigration, you could have a stipulation for religion, right?
Oh yeah, there's nothing here that says anything about immigration. Obama's talked about, this is against our laws, and the existing immigration laws requires us to ask the religion of people as they come in, because it is a matter, it should be a matter of consideration.
Who makes the final consideration as to who gets to come in the country? Is that a congressional matter?
Well, Congress should pass the law giving the requirements, and then the president would execute that. So he'd be the one to actually, his departments screen the people, and he's just wanting to ignore that.
So but how the Constitution operates, could somebody, if they wanted to, in the executive branch or in Congress, say Muslims are no longer allowed to come to the country? Mm-hmm. And that would stand?
It would probably get thrown out by some judge, but there's nothing in the Constitution that would prevent that.
How would it get thrown out, though?
They would say it was unconstitutional, a violation of the First Amendment or something.
But they don't have those rights. They're not citizens.
I know. That doesn't matter. There's nothing there that says they couldn't. Okay. That doesn't, like I said, the judges, going back to those papers you read, the Federalist Papers, we talked about will versus judgment. They're much more just will. What do they think should happen? And they go to the Constitution and try to make it say that. Okay, so the point here is this is just a restriction on the national level. It is not a restriction on the states. That does not prevent, in fact, it did happen in 1961. The Supreme Court declared that this also applied to the states. So there was a, I don't have the state. To be a public notary in a certain state, you had to profess belief in God, just a very generic thing. And that was declared a violation of the Constitution. So. All right. Historically, can anybody think why we know this is just applying to the national government? We can read the words. It says under the United States. It doesn't say the several states. The United States. So the words say that. But historically, how do we know this is also not applying to the states. To me, the clearest example is Massachusetts had an established state religion until 1830. They had a combined church and state. So anyway, it was never challenged, never discussed that Massachusetts was violating the Constitution. This applies to the national level. So we're going to read the First Amendment. We'll get to it today since we're making such good time. That's a restriction on the national level. We'll get there in a minute. Okay, otherwise, fairly straightforward thing. A no religious test for national level offices is all that it says. Article 7. Should we have a moment of silence? Wait, that's a violation of religion and freedom somehow. You know, the soccer or the football coach who prayed at midfield after a game and his players came voluntarily to pray with him. That was a violation of the Constitution. It's been this fall. If I remember right, the coach got fired. I didn't follow the whole case, but he didn't require them to come. He went to pray after the game, and his players came to pray with him, and that was a violation of the Constitution.
Dearborn, Michigan has Sharia law.
Well, that's okay. I would go completely bonkers, except for the fact that Jesus promised Christianity was going to be hated. Right? Any religion is fine except Christianity, and that's okay. Well, we were promised that, so it does. We go from going postal to maybe just going FedEx or something. not quite as bad. So, going postal, know what that phrase means? Came from workers at a post office that got mad and came and shot everybody up and killed a bunch of people. Going postal. Takes me from that level and backs me down a little bit. So, all right, Article 7. Now it'd be going Muslim, right? Be a better phrase. All right, Article 7. The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same. Okay? All right, so 9 states had to ratify this thing, and it says conventions, not state legislatures, so there had to be a special meeting where people were elected to go to the meeting, and that meeting would make the decision. And 9 states had to do that. Why 9? Because it's a square of a prime number. That's not it. Yeah, that's true. You're a math major, right?
That was my sister.
Oh. Any math majors in here? There's something wrong with the world. Math is a beautiful thing. Okay, there's nothing mystical about 9. Why did they pick 9? Well, if you were Louis Farrakhan, you would read into this, and somehow there'd be some mystical, cosmic relation between 9 and the whole universe. But there's nothing there. So.
I'm thinking because of, I don't know, the voting thing with the...
Think back to the Articles of Confederation. How did a law get passed under the Articles? How many states had to approve it?
What was it then? I was going to say that.
Oh, you should have said it. You'd have looked really intelligent. we would know better, but you would have looked that way. So I'm kidding. It's 9 states had to pass a law under the Articles, so they use that same standard here. 9 had to approve it. And technically, it just would affect the 9. The other 4 could still work under the Articles of Confederation if they wanted. And talk about an awkward situation. It didn't happen. It would be unpractical, especially with Virginia and New York not having ratified it by the time 9 states had. So we'd had, think of the eastern seaboard with those 2 states not part of the country. It wouldn't have worked. So eventually all of them do, but the requirement is just 9, and it harkens back to the Articles of Confederation. All right. Let's read the last paragraph, and we're done. Done a convention by the unanimous consent of the states present the 17th day of September in the year of our Lord, 1787, and of the independence of the United States of America, and the 12th of America, the 12th, in witness whereof we have hereunto subscribed our names. I think he's writing is that in your copy?
No.
Oh, man, that's why you're all flipping. Okay, right before all the names. There's that little bit. I was only going to comment that I think he's writing a 4-page paper there. So instead of writing out 1787, it's 1787. All right, and there we have all of the people at the convention that were there on that day sign the thing. And unanimous consent of the ones that were there. So seemed like there was somebody who just didn't come that day because he didn't want to spoil the mood. He didn't especially like it, but knew he couldn't stop it. I can't remember who that was now. So. Oh well. All right, questions about the Constitution? Very broad, wide question. We're done with the original text, yes. Now I just have all the amendments to look at. So. Okay, I do want to start into the amendments today. Like I said, we're I think on schedule to get through everything, but I'd rather not be scrambling on the last day of class. I like to be able to review for the final, a little bit at least. So, all right, let's start into the first section of amendments, and this first section will take us the most time, all right, because there's a lot of meat in here to look at. The first 10 amendments all were passed in one fell swoop, December the 15th, 1791. Does anybody know what we call those things? The Bill of Rights. Okay, so that's the first 10 amendments. They went through as one block, basically. You know, they were proposed together, et cetera, et cetera. There was one that actually got proposed. This is an interesting little tidbit of trivia that you could pull out sometime. And it wasn't ratified till 1992. The very last amendment was proposed at this point. But just sat there languishing without the 3/4 required. So it wasn't until 1992. A group of college students realized this amendment was still hanging there and made a push to get it added. So I don't know if there's any more, so don't get excited. We'll add to the Constitution. All right, so the first 10, altogether, the Bill of Rights. Most of this is pretty straightforward. But again, that hasn't stopped Congress from muddying the waters, and especially the courts from muddying the waters. So, all right, let's at least start into the First Amendment. We may not get the whole thing done. The First Amendment, there's a mouthful here. Let's just read it, and then we'll go back and pull it apart piece by piece. I'm sorry, I forgot to mention one thing. Generally, this whole block of amendments are requirements on the national government. That is not exclusive. There are some where it's not specified. But generally speaking, here you should think this is a requirement for the national level. So the courts have declared that almost all of it applies to the states as well, which is difficult. If you look at Amendment 1, it says Congress shall make no law. To get that to mean Indiana shall make no law. But that's what the courts have declared. The phrases have been incorporated to the states through different court rulings. So, but the general thought is these are restrictions on the national government.
I only have 12 amendments. Is that a problem? Are we covering all?
It's going to cover all of them. Are they not in your book?
I only have up to 12.
Oh. Maybe you have a really old book. Or it could be that at the time is that in your storybook?
Yeah, this is.
There were probably only 12 at the time this was written. So I'm sorry. But yeah,
Who has all of them? Just wondering.
I would say Google it, but you're using pen and paper. So, all right, well, we're not going to get to all 12. We're not going to get past 12 today. maybe not tomorrow or Friday. So, all right, Amendment 1. Congress shall make no law respecting an establishment of religion or prohibiting the free speech thereof, or, and it goes on here, Congress shall make no law abridging the freedom of speech or of the press, or the right of the people to peaceably assemble and to petition the government for a redress of grievances. Okay, so we have 3 different thoughts there. The first one is religious freedom, the second is freedom of speech and of the press, and then the last one is this peaceable assembly and petition the government. Those are the three thoughts. Let's look at the religious freedom clauses today at least. I've got almost 2 pages of info on this, but a lot of it is way more than we need here. Let's first of all look at what this is actually saying, okay? And then we'll discuss how this has been warped and morphed and changed and what the claim is today. They're 2 very, very different things. Kind of like the interstate commerce, it has gotten to the point where it's any activity having any ultimate impact in more than one state, or whatever the phrase was. How we got to that point. The same thing has happened here. This has been warped to mean much, much more than it did at the point. So, all right. First of all, we have Congress not being allowed to make a law respecting the establishment of religion. So Congress can't get close to, is the idea, picking a certain denomination. This is going to be our national religion. Presbyterian, the black guy running for Congress or for president? Carson. Seventh-day Adventist. He becomes president, and he goes to Congress and says, I want, Seventh-day Adventism to be the national religion. They can't make a law respecting that. They can't get close to it, is the thought. Anything along that line. Okay? And then the other half is prohibiting the free exercise thereof. So Congress can't say we're going to be Seventh-day Adventists, and they also can't say Baptists can't worship in America. So they're not allowed to pick certain denominations and prevent them from worshiping. And they cannot pick one and make it the national religion. So Congress can't do either one of those things. And that's all it means. So how does this restrict governors or state legislatures? I'm not asking you to give the modern interpretation, but based upon what the Constitution says here, what restrictions are put on governors and state legislatures and principals of public schools here in Chesterton by this? We have 1 vote for absolutely nothing, I think. Anybody agree with that? Yeah, there's absolutely nothing. There's no restriction whatsoever. Okay? I don't have the whole story, so that way I can make it better if I don't know the whole story. But Diana Gonzalez's girls were they go to the public school, and they were told, or it was either them or a friend was told, they could not pass out Christmas cards with Jesus on them because it's a violation of the Constitution.
But they're not part of the school system at all. They're just...
What's that? No, they go to the public school.
Oh, I know they go to public school, but they're not like part of the administration at all. So they
No, but that's... I would love for somebody to say, oh, you violated the First Amendment, to say, yes, I'm Congress, what else could I do? Same Congress, but we've gotten to this point where the principle of public schools, they are scared to death of somebody claiming that their religious freedoms were violated and they were offended by a card with Jesus on it. There's a kind of a dark underbelly to this thing. If there's not, I don't know if there's a white underbelly, but there's a dark underbelly. That principle is personally liable. Right? It's not just that if somebody gets offended, they're going to sue the school district and the school district is losing money. He personally is liable. All right? Which is I mean, there are all kinds of places. Any other sane place, the school district is responsible. He's acting as the principal, official capacity as the school district. The school district takes responsibility. But the law, the courts have actually said he personally can be sued and made to pay. So I can understand a little bit how they're scared to death. They should man up and that's part of the responsibility. I'm not having anyone challenge me on that here yet. Hopefully no one gets scared about Jesus cards being passed out. But there's that dark underbelly that makes me at least appreciate their position. But we've gotten to that point where the principal is worried about kids passing out Christmas cards in their school because it's a violation of the First Amendment, which is insane, right? Insane. On pretty much any level. I mean, just read the words. It says Congress, okay? Or how many have heard of fights in cities about a nativity scene being put up? Okay, yeah. I would love for the school board or the town board just to call a press conference and say, we're not Congress. What's the issue? Okay, they're not Congress. The First Amendment does not apply. Okay? Or the governor of a state putting a Christmas scene outside the governor's mansion. And, you know, yeah, I'm not Congress. Right? So the courts have ruled that states have to follow this. All right? Once we get to the 14th Amendment, we'll look at the phrase that they use to do that, but it's one of those where if you read that and you say, oh, that makes sense, you should be banned from voting or driving cars. Or it's such a stretch of common sense that it's insane. Okay, so that's what it means. Congress is restricted. They can't pick a national religion, and they can't particularly exclude certain religions. And that's it. Okay. Where are we at here? A couple other thoughts here. This part of the reason for this was to protect states, Massachusetts particularly, that had an established religion. Virginia had just gotten rid of theirs within the last 10 years. So this wasn't some antiquated thing where states picked a particular brand of Christianity as their official religion. It was still happening, and part of this was to make sure that the states had the liberty to do that. If Maryland wanted to go back and be an all-Catholic state, you know, only Catholics got to, would that be an improvement? I don't know. Only Catholics could hold office. You know, you had to, when you took your oath affirming to uphold the Constitution, you also had to take the Holy Mass and cross yourself or something. You know, it was intentionally to protect the states having that freedom and liberty. Congress didn't have the authority to say, oh, no, that's unfair. It was outside their jurisdiction. Okay? Let me read you some other these are both from Joseph's stories. You probably remember these paragraphs. He was talking about this amendment, making the point that the Founding Fathers were not, or that they were preferential to Christianity. They recognized Christianity as being important. So it wasn't like they were saying, you know, we have to accept Muslims and Hindus and everybody on the same footing. Here's what Story said. We're not to attribute this prohibition of a national religious establishment to an indifference to religion in general, and especially to Christianity, but to a dread by the people of the influence of ecclesiastical powers in matters of government. A little bit further down, probably at the time of the adoption of the Constitution and of the amendment to it, now under consideration, the general, if not universal sentiment was that Christianity ought to receive encouragement from the state, so far as such encouragement was not incompatible with the private rights of conscience and freedom of religious worship. An attempt to level all religions and to make it a matter of state policy to hold all in utter indifference would have created universal approbation, if not universal indignation. So anyway, they were not indifferent to Christianity. They personally were preferential to Christianity, but they did not want to allow the national level of government here to pick a particular sect of Christianity or any other religion for that matter. Okay, questions about what it actually says? I've hinted a little bit at how this is actually interpreted today. Does anybody, well, let me tell you some, we're out of time. Let me give you a couple of other things here. This would be more the modern interpretation. One important thing here with the modern interpretation is the phrase wall of separation. Have I heard that phrase before? People say things like the First Amendment erects a wall of separation between the church and the state. Okay, implying that neither one should have the ability to influence the other. Pastors and churches shouldn't be able to influence what happens in the government, and that is not the case. The First Amendment, it's the phrase semi-permeable membrane. Anybody have biology?
Yeah.
The one where things can go one direction but not the other. Is that the right phrase? It sets up a semi-permeable wall where the government can't put its tentacles into religion, but was definitely wanting to allow religion to influence the government. All right, this wall of separation is not there. Does anybody know where the wall came from, where that phrase?
Was that from a Jefferson letter?
Yeah, Jefferson wrote a letter And it's especially ironic if you look at the letter. It was written to the Danbury Baptist Association. So here we have the president writing to a group of Baptists. And he concludes it with this phrase: I reciprocate your kind prayers for the protection and blessings of the common Father and Creator of man. Now think about they're saying that Jefferson's letter erects this wall of separation. And in that same letter, he said he reciprocates. He prays back. He returns their prayers. All right, so anyway, by the modern interpretation, his letter is a violation of the Constitution. So, but anyway, that wall of separation, that catchphrase is used, that cliche, to use Pastor Damon's word from Sunday night, is used to describe what this thing actually means. And it's not in there. Jefferson was not trying to give us some special insight into what it was saying. He was writing a letter to them. It did discuss religious freedom, but that was not the intent. All right, a couple other things here. With that wall of separation, it really sets up kind of a schizophrenic situation of what this thing means. The Establishment Clause is said that it the government can't give any preferential treatment to religion, and then the free exercise says the government can't prohibit people from freely exercising. So it sets up this contest of the example I always think of is with churches being tax exempt. People say, oh, we can't tax churches because it would be prohibiting their free exercise of religion. But then other people say, wait a second, churches aren't paying taxes. Aren't we giving them some sort of preferential treatment? Right? And it sets up the situation where the courts are always trying to decide, all right, does the free exercise or the establishment part here bear weight? Because they go at odds with each other. Lots of things that are declared constitutional seem to violate one side or the other of that thing. So it sets up a very strange idea. All right, let me give you some other examples. A moment of silence has been declared unconstitutional at football games and other places like that. Think about that. Chesterton High School, a football game, let's have a moment of silence. Or to start the school day at Chesterton High School, it would just give the kids a moment of silence to take the last dose of some narcotic before they hit class, but declared unconstitutional. But Congress having a paid chaplain, that's constitutional. All right. I have prayers at the football game are constitutional, but the bailiff at the Supreme Court, starting with these words, God save this honorable court, that's constitutional. So it really sets up this very strange situation where we have these two competing ideas, and which one is the court going to decide wins in this case? And really the correct interpretation is, well, no, it's not a competing idea. It's that this is a restriction on Congress. Chesterton High School can do what they want at a football game. They can require people to take Catholic Mass as they enter the stadium. As you know, it's up to them.
But I guess at this time the National Board of Education wasn't around, and that influences things more because technically the Chesterton High School in a way is part of the government because it's a government school, right?
Oh yeah, it's a government school. You're saying that Congress gives money to the states, which gives money to them,
So
and if that money is used,
money
yeah.
to endorse religion.
That's part of it. More directly, the National Department of Education will say to the states, if you don't do what we want here, we're not going to give you the money. And it really becomes a big bribery scheme where the government takes the money from the citizens of Indiana and sends it back if the state is willing to toe the line. And that's the issue with the school in Illinois where the guys demanding the right to be in the girls' locker room. The money is being threatened. And that's what. I was refreshing the other day. I heard somebody representing the girls talking about them. And says, "What about their privacy rights?" Here, this guy. There's a curtained-off section where he goes to change in the girls' locker room. That he's not satisfied with. It's still a violation of his femininity, or I don't know. But he walks through the locker room. What's you girls happy with that? I wouldn't be happy with that. I mean, their rights don't matter. It's the guy who claims he's a girl. His rights are trumped. One of those girls needs to be on the hockey team and just not be paying attention, and just stand up, and just getting dressed, and or a baseball team, or have a can of mace with them. The guy's a pervert. All right, and this is he's sick in the head, and for us, for the national level of government to do that, it's the money that gives them that authority. That, among many reasons, is why we should get rid completely of the Department of Education. So the school district should be willing to say no. We don't want the money. We'll figure out how to pay for it ourselves. I mean, that's I think in this area it's somewhere around 11,000 a student comes from the state. The other 3,000 or 4,000 comes from the national government. If you can't run a school in 11,000 a student, you've got some serious problems.